Good morning. I'm Gary DeWaal, and this is Bridging the Week for June 6th to 10th, and today is June 13th, 2016. Last week, a Commodity Futures Trading Commission staff roundtable explored elements of proposed regulation automated trading. But the most important development occurred earlier in the week when Chairman Timothy Massad said the agency would be willing to issue the controversial regulation in parts with requirements on risk controls coming this year. Separately, CME Group fined a member firm for an automated trading system that malfunctioned, while the Financial Industry Regulatory Authority formally announced the date by which principal developers and supervisors of algorithmic trading systems must register. We have a few articles on automated trading system and regulation, as well as other important matters, so let's get started. Staff of the Commodity Futures Trading Commission sponsored a roundtable on proposed regulation automated trading last week in Washington, D.C. The roundtable addressed 5 topics. Amendments to the proposed definition to direct electronic access. This is important to trigger the possible registration of a new class of algorithmic traders as floor traders. Quantitative measures to establish the population of persons impacted by the proposed regulation. Alternatives to require each person defined as an AT person to implement and utilize pre-trade risk controls and to comply with certain development, testing, and monitoring requirements in connection with so-called algorithmic trading systems. AT persons' compliance with requirements under Regulation AT when using third-party algorithms or systems, and source code retention and access. Among other matters, the roundtable discussed whether metrics to be used under the Markets into Financial Instruments Directive 2 in Europe to identify high-frequency traders might have relevance in determining the universe of persons to be covered in whole or part by Regulation AT, and if metrics were used, should there be absolute or relative criteria. The roundtable also considered the potential benefits of cross-border harmonization of regulation regarding AT persons and algorithmic trading systems. In addition, the roundtable explored how best to control the risk to markets posed by AT persons and algorithmic trading systems that access designated contract markets through direct electronic access, how future commission merchants might assess the adequacy of their clients' algorithmic trading systems and controls, what due diligence of any other algorithmic trading customers might be appropriate for FCMs to conduct, how could AT persons comply with regulatory requirements when using third-party algorithms and systems to establish a level playing field compared to AT persons that utilize their own developed software and systems, what is source code, what parts of source codes are typically reviewed if something goes wrong with an algorithmic trading system, and what are industry best practices to track changes to source code. However, in a more important development, on the day before the CFTC roundtable, Chairman Timothy Massad expressed his quote-unquote willingness to break up proposed Regulation AT and roll out different parts quote-unquote in phases. In a speech before the Global Exchange and Brokerage Conference in New York City, Mr. Massad indicated that his priority was for the CFTC to issue a final rule related to risk controls this year. Richard Larkin, a non-member, agreed to pay sanctions in excess of $300,000 to resolve disciplinary charges brought by the New York Mercantile Exchange that he facilitated exchange-related position transactions for a customer that the customer never authorized and that included unauthorized markups on the customer's futures positions. Mr. Larkin's alleged infractions occurred on numerous occasions between April 27, 2010 and August 20, 2014 that involved the company Mr. Larkin owned, Hedge Solutions, Inc., that took the customer's order, an affiliated company, Northland Energy Trading, that engaged in the EFRPs opposite the customer. Mr. Larkin agreed to pay a fine of $140,000 and disgorgement of $155,799 and to serve a 15-day suspension from trading CME Group products to resolve this matter. Separately, Toji Trading Group, a member firm, resolved charges that on multiple days between July 2012 and March 2013, trades for the firm involving 10-year T-note options on futures frequently self-matched because the firm's automated trading system had quote-unquote configuration errors and malfunctions. In some instances, said CME Group, the self-matched trades comprised 100% of individual strikes market volume. Toji Trading agreed to pay a fine of $75,000 to settle this matter. Also, Manufacturers Life Insurance Limited and Wayne Lamb agreed to pay fines totaling $110,000 for allegedly engaging in EFRPs on 3 days in 2013 to transfer positions from one manufacturer's life account to another. The Financial Industry Regulatory Authority announced that its new rule requiring the registration of persons associated with a member that are either primarily responsible for the development of an algorithmic trading strategy or the day-to-day supervision of such activities will be effective January 30th of next year. By such date, all relevant persons must have taken and passed the Series 57 exam and be registered with FINRA as a securities trader. Under FINRA's rule, an algorithmic trading strategy is an automated system that generates or routes orders, but does not include such a system that solely routes orders in their entirety to a market center. All algorithmic trading strategies involving equity and preferred or convertible debt securities are within scope. And finally, Oppenheimer & Co., Inc. agreed to pay a fine of $2.25 million and restitution of over $716,000 to customers to resolve a disciplinary action brought by the Financial Industry Regulatory Authority that, from August 4th, 2009 through September 30th, 2013, it sold non-traditional exchange-traded funds to certain of its retail clients when its policy and procedures precluded such sales. The relevant products included leverage, inverse, and inverse leveraged ETFs. Also, RBC Capital Markets consented to pay a fine of $125,000 to FINRA because in connection with the settlement of an arbitration involving two customers, the firm included language in the final agreement that the customers would not object to any effort by the firm to remove reference to the arbitration in RBC Capital Markets CRD registration records. However, said FINRA, such language violated an express FINRA rule that prohibits a member from conditioning or seeking to condition the settlement of a customer dispute on the customer's agreement not to object to the removal of reference to the dispute on the member's CRD filing. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and until next week, ciao. Have a great week.